18th, 2023. If you all will please join me in the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Okay. First order of business here is approval of tonight's agenda. Everybody satisfied?
Yeah, I make a motion to approve the agenda for October 16th, 2023.
Nope, that's
December 18th.
December
Yeah.
18th. What am I reading?
your next line down.
Approval.
Can I get a second?
Second.
Ed seconds. All in favor, say aye.
Aye.
Opposed? None. Okay, now, Tony, you can
There you
approve the
go.
minutes.
October 16th. Or my
All right.
paperwork.
You want to make that motion?
Yes, I want to approve I make a motion to approve the minutes of October 16th, 2023.
Okay, I will second that. Everybody okay with that? All in favor? Opposed? None. Done with that. Boy, this is a big change from the last three meetings we've been in here.
Yeah, where is everybody?
Hello.
I was able to find a parking spot out front, and man, there's no one here for public comment. But you're more than welcome to start off with public comment. Okay. Well, nobody's here for public comment, so we will move on to old business. We have no old business. So we will start right in with new business. And I will read out item A, which is variance 23-02, variance application submitted by Gerald Sousey to seek relief from Town Code Section 36-202D4, minimum side yard setback for the property located at 17 9th Avenue. Performing the duties, we are performing the duties of the Southern Shores Board of Adjustment moving forward. So with that, I'm just going to read procedurally what we're doing here. It won't really pertain because there's no one here other than the property owners, but I'm going to read this anyway. These are comments to be read at the hearing. Okay, this is not a legislative public hearing where the public is invited to give opinion and provide general comments or guidance to the board about zoning text amendments. This is a quasi-judicial hearing. Only aggrieved parties may participate. A member of the public may participate if aggrieved. An aggrieved person may give relevant testimony under oath. No opinions, just testimony based on facts. It is just like taking the stand in a courtroom. An aggrieved person is subject to cross-examination by any other party and by this board, just like court. To be aggrieved under the law, you must be directly and substantially affected by the board's decision. Guidance from past NC cases and the North Carolina School of Government help us understand that to be aggrieved, you must be an immediate neighbor whose property use, enjoyment, and value will be adversely impacted by the board's decision. If you are an aggrieved person and want to participate in this quasi-judicial hearing by giving sworn factual testimony or wish to cross-examine any witness during the proceeding, come forward to the podium to be sworn in. There is no aggrieved persons on record in this meeting tonight.
We'll still ask Sheila to swear myself in as staff and Mr. Susi as the property owner and applicant.
Okay. Sheila, if you can do that, please.
Just stand up and just raise your right hand, please. Do you swear that the evidence you shall give to this board in this action shall be the truth, the whole truth, and nothing but the truth? So, all right.
Thank you. Okay. All right. If everybody will turn to the order of hearing for the variance application. Pretty stock material here. We've used a shorter version of this, and this is the version that Jay Wheelis, our attorney, recommends that we use. So we are going to follow that. Wes, can you possibly pull that up on the screen? Thank you. Okay. We're going to start off with recusal statements here. I'm going to read the following questions, and at the end, I'll poll each board member. Has any board member communicated with other board members, the applicant, or town staff about this application? Does any board member have a fixed opinion that is not susceptible to change? Does any board member have a close familial, business, or associational relationship with the applicant? Does any board member have a financial interest in the outcome of this matter? Does anyone answer yes to any of those questions? None. Okay. Now we will move into item 2, which is the hearing, and it's evidentiary hearing. I'll ask you if you wouldn't mind coming up to the podium, and that way we can make sure everybody hears. And is it Susie or Sousie?
Susie.
Susie. Okay, thank you. All right. Mr. Susie, you are the applicant, so it is your burden to present the evidence as you know it.
Okay. Pretty much running from memory. In February, I purchased a shed, and on advice from the company I purchased it from, they said you didn't need a permit for it. I don't remember the exact words, but that's kind of the outcome. So I did not get a permit. In June, when I was meeting with Kevin Clark at my property to do some review of a permit I was going to submit for an enlarged deck and rebuilding my crow's nest, he looked at the shed and said, "That looks new. Did you get a permit for it?" I told him I did not. And he said, "Well, you just attach it to the permit for the deck expansion," which I did. When the permit was submitted and the shed was drawn in on the plat, they noticed that part of the shed was into the setback. So they said it would have to be moved. So I met with Wes and myself and my contractor, and we looked at the plat that was on file, and we all agreed that the location was on the side of the house would be a good location. Part of getting the permit was to have a survey done at the end. So once the shed was moved, the deck was enlarged, and the footprint wasn't going to change, we had a surveyor come out. He surveyed. A week later, he provided me the survey and the report, which showed that the shed was now located about 70% in the setback. What we didn't know was the 2 previous surveys, one done in 2005 and one done earlier than that, were incorrect. They never located the back pins of the lot, they just guessed. So the whole lot swayed to the left about 15 feet, putting the shed in the setback. As soon as I got the permit, or not the permit, the plat, I came and I talked to Wes again and said, "What can we do?" And we looked at it, and he basically said, "You need a variance." And that's kind of where we are now. I had to pay to get the shed relocated. I had to empty it out and fill it up again and all that. And just as I was filling it up with all the stuff that was now in the house, I got the plat. So kind of it. for the sequence of events.
Okay. Well, if that's, your narrative so far, we will proceed to ask questions of you, if you don't mind staying up there.
Yes.
That way you can be on record and I can hear you on YouTube. Okay, so board questions.
Who is the surveyor?
The first surveyor,
Yeah, that had
I could tell you just a
a
second.
pretty significant error.
Yeah, it is a significant error, and that surveyor was Midget and Associate. That's the one that was done in 2005. I don't know what the date of the earlier one was because I didn't get a copy of that.
When you say you had two prior surveys, where did they come from?
This office.
So the surveys, everything survey-wise came from here, the 2005 that we have a copy of. And then there were two other surveys on file here.
There was one in 2005 and there was one earlier than that.
The one in 2005 was done, was ordered or asked for from the Boyers did you buy the property from the Boyer family?
Yes,
Okay. And yeah, so that's Midget and Associates. And then there were two other surveys?
one other.
One
prior.
other besides this, okay. And did they both appear to be the same coordinates and stuff so really this survey up here is what you went by?
Correct.
What was, you had a cost apparently of moving the shed the first time, am I correct?
Yes.
And how, approximately, what was the cost for moving it at that point?
450.
450?
And there was also a delivery charge of about the same
Yeah.
when I purchased it.
Where was when you had it set in March, where was it on this survey?
It was,
Or Wes, you can,
if you look at the survey, you can see the rounded deck in the corner.
right,
It was adjacent to that against the side of the house and against the deck. So it fit perfectly in that corner.
right. But probably was still in the rear setback even at that point?
About, according to this survey, about 1 foot of the front corner was in the setback. And of course, when you look at the new survey, it would have been much further in the setback with the proper survey.
Right. So there's a setback line that is off on an angle from where the new deck is. Is that where it was?
Yes, it was right next to the 25,
Right in there.
right in that corner.
Right. And did you build that fence since you've owned the property that goes along the
Yes,
property
I
line?
did build the fence, and I now know that it's encroaching on other property. When I put the fence in, I went by the cleared property lines.
Mhm.
So there was no fence there prior, but the lines were clear, and I just put the fence where the clearing was. I didn't have a plat at that time.
Right.
And it backs up to Hillcrest, which is the Civic Association property. It's not, right, wrong, or indifferent, it's not hurting anyone with the fence being there.
Right. So you never came to town hall for any purposes until you were ready to start looking at building your new deck and the, work that you were doing out there.
Right.
And was the contractor?
Gary Ellert, he goes by Paragon Deck.
Mm-hmm. So did he have any inkling of, any setback problems or anything like that when?
Well, when he took the old plat and drew where the shed was and then brought it to the town planning office for the permit, they looked and said, gee, that looks like it's in the setback. And that was the first indication that we had that it was
Right.
encroaching.
So when you started out with Kevin met you out there, and then you came back, looked at the old survey from 2005, and Kevin said, yeah, this was probably your best bet, is to put it.
It was actually Wes that said, this is your best bet.
Okay. And at that point, nobody knew. I mean, it's highly unusual for a survey to be off that much.
Yeah, and the interesting part, the fence on the side of the house that I put in right along the clearing is right along the property line. And that's sort of coincidence, because when I got the plat, it showed that I had 15 feet more property beyond the fence.
Yeah. And, when that house was built in 1972, I believe, is what Dare County has it at. There were 10-foot setbacks.
And it's still within the, well, according to the old survey, it was still within the 10-foot setbacks.
Yeah.
So is it routine, when somebody comes to the town to, move a shed, that they're not asked about a survey, or? I mean, this could happen repeatedly.
Well, we'll ask Wes when he gets up there about all of that. We'll stick with Mr. Susie now. Let's see.
Your neighbor at 20, you're 17 or 19?
17.
At 19, that's also a new resident. Has he said anything about the fence or anything? Because he recently moved there within the last 2 years.
I did not know there was, the resident at 15 is new within the last
It's
2 years.
15 is the new one, okay.
He did not know I had a shed until I told him. He knew that I had moved the shed,
Yeah,
and he agreed that where it's at was a good location because you can't see it from the
you
street.
can't say it, yeah. Okay.
And when he found out that I may have to move it to the driveway, he said, geez, it looks a lot better where it's at.
How did you get the shed in there initially? Did you come through to go to the backyard?
From the side yard, and it took a lot of work. It took us 3 hours to get the shed in with what they call a bull mule or whatever.
Uh-huh.
It's just heavy duty forklift that's designed to move sheds.
Right.
And then when we moved it to this location where it's currently at, the guy came out with an even better machine. It wasn't the shed builder, it was one of his contractors.
Uh-huh.
So it was easier to move. Right now, if we try to move it from there, we're going to have to cut down trees again.
But when in March, when they brought the shed in, did they come that way on that side of the house? Or the
Yes,
other
they
side?
came, as you're looking now, they came straight in there. I had to tear out the whole front of the fence to put it in
Right.
and rebuild it. And then when we moved it here, I had to tear the fence apart again, the front, and rebuild the gate. But it took a lot of moving it a little bit, picking it up,
Yeah.
pushing it over.
Yeah.
Because, they gave me the parameters of length and width, but they didn't give me the parameters of swing.
Mm-hmm.
So we had to cut limbs off of trees and that have since grown back. And again, it would be unless he came back with the real good mule, we'd have to cut more trees down.
Right. How did he anchor that?
It's anchored according to code. Kevin Clark actually looked at it when he came out to give the final on the deck, and he put a note saying, shed reinstalled does appear to be installed properly. So
Okay.
he looked at it while he was there, and he agreed that it met code.
Mhm.
Because you really can't see in the pictures, but there are four corner anchors.
Right. Do you have any mechanical in there, lights, plumbing,
No,
heating and air, nothing?
No,
It's
the
just a
most-
shed.
the most I will put in there is probably a light.
Yeah, with an extension cord or something. Yeah.
Right. Now, you can see the anchor in this picture where he enlarged it in the
Oh,
corner,
yeah, yeah.
and that goes down 2 feet. It went down so hard that I bent the pipe I was using to twist it.
Mhm. Anybody have anything further for Mr. Susie?
I don't.
Can I add a couple more notes?
Sure, absolutely.
The current location of the shed, the outmost corner is about 35 feet from the neighbor's fence, and it's about 50 feet from the closest part of the neighbor's house.
Mhm.
So as far as, meeting the spirit of the setbacks, it meets the spirit by distance.
Right.
And I think that's it.
Mhm. Okay, Wes, it says here that you're on board for any cross-examination of Mr. Susie. Do you have,
I don't have any questions, Mr. Chairman.
okay.
Okay.
Anybody else?
No.
Okay, then. We'll probably get you back up there again, but you're free to sit down now, and I'm going to call on Wes, and we're going to ask some questions of him.
Okay, thank you.
Thank you. Okay. Questions for Wes? Jan, you kind of started down that path about coming in for a,
Right, if you're coming to, move a shed, or is it customary for the town planner to look at a plat and give direction? I have no knowledge of that, so give me some history as to.
It's not uncommon for someone to come in and we offer them or provide them with a survey or plat in the file. The town has never purged any of our permit files. We have permits that go back before the town was incorporated from Dare County. And in most cases, for a developed property, we have surveys and permits and building plans and everything. So when someone comes in and they have an issue, we try to help them by saying, well, here's a survey from whenever. And as well as elevation certificates. You can't get rid of elevation certificates, but we have those that go back a while. So I guess to answer the question, it's not uncommon for us we're trying to help them by assisting them by saying, here's a survey. And it's not in every case where we say we recommend they go in this location. I would say that's not all the time.
So is your survey, what survey is, now that this one that we have in front of us is a real survey? I mean, an accurate survey?
The one that is right here from 2005 is the one that we had in the file from 2005. And then the other one is the one Mr. Susie obtained per a condition in the zoning permit to obtain an as-built survey once the shed and the deck were done, in order to verify that lot coverage and setbacks had been met.
It was done after the fact.
So yeah, this survey right here was done
As your as-built.
Does the as-built survey on August 10th of this year.
Well, and
And looking at the distance between the 15-foot side setback from the house and the dimensions of the shed he explained that he wanted to put in, I've recommended, said this right over here should work. The site plan that was submitted, it showed the shed drawn in this location within the line so that it did not encroach.
in your time at looking at surveys, as-built, preliminary stuff, have you ever seen a survey this far off?
Not that I can recall.
I-
One thing,
I
the
haven't.
thing that jumps out to me the most is, 9.3 feet from this corner
Yeah.
and 15.8 feet from this
Oh, I
corner.
know. There's a ton of,
There's 18 feet on this side in the new one. And I don't know what it is on this one.
but, I think anybody would do the same thing. I mean, there's no need in paying, I don't know what an as-built survey is now, $1,500 maybe, or more.
I don't know that.
I mean, like Wes said, he went by what was on the survey, and the surveyors signed their name to it. That's their license. I mean, if this guy was still in business, he'd be in big trouble.
Yeah, the coordinates on the southern property line, because north is this way,
Mm-hmm.
86, 49, 49, 89, 53, 33.
Yeah.
Wes, curiosity, did you look at the surveys from the adjoining properties by any chance?
I did not, no, sir.
Is there a subdivision plan for this that covers this property?
Like a plat from back when the properties were subdivided. Not that I'm aware of in our files, but there most likely is at the Register of Deeds. And I have not gone so far as to investigate that.
How many more lots is Midget surveyed in this area?
I don't know. This, I couldn't tell you. This is the first one that I recall seeing from this individual,
Yeah, I
Benjamin Harden with Midget and Sons. I don't recall seeing that name.
They
Before.
survey in North Carolina and Virginia.
Oh, Moyoc, okay, I was thinking
Yeah.
Manio.
No, more, yeah.
Oh, yeah.
Was there any indication, I mean, why was the survey in the file and not you said the house plans weren't in the file with this survey?
They may have been, I don't know. The
Yeah.
house plans might have been. I wasn't looking for that. I was just looking for a survey.
Well, I wonder if Boyer, when they ordered this survey in 2005, what was the reason? I mean, was it the bank or
I'm not sure.
no indication in the file?
Yeah, at the time, I was looking for a survey to provide Mr. Susi so that he could hopefully find a new location for the shed so that it met all setback requirements. I wasn't looking to see if this was associated with a previously issued building permit
Yeah,
or anything
Nothing.
like that.
nothing other than this survey really to help.
There might have been, I mean,
Yeah.
but as far as when you're trying to figure out if a shed will fit in a certain location, I mean, a survey is your best tool to do that.
I think most anybody would look at that survey and say, yeah, you got a ton of setback on the west side. And by the way, I think when you were calling the west side, it's in the staff report.
Did I have
You
the
got-
direction mixed up in the staff report?
Yeah, you were saying placing you said in the second line
On
in
the
the
east
bottom
side,
paragraph.
the east side, yeah, that should be,
Yeah,
that should
you
be
had-
west side, my
You had
apologies.
east side there and then two more places on the next page.
My apologies, yes, sir.
Okay.
I did miss it on the title block. it is Lot 9, Block 54, Seacrest Village, which I assume is the original subdivision plat. It may be good at some point to compare both of these surveys to that. And so if the structure were less than 100 square feet, they wouldn't need a building permit, right? But they would still need to comply with setback requirements.
Our office, since I've been here, we have not required a building permit for a shed if it's less than 12 by 12, 144 square feet. But a zoning permit is still required regardless of the dimensions or size so that it meets setback requirements and lot coverage. So when folks inquire about a shed, which is very common, that's what we tell them.
So is that 12 by 12 requirement for a shed that you can roll in?
Either
or
any type,
Any type of stick-built,
yes,
on-site built?
pre-manufactured or stick-built.
Mm-hmm.
The one, if it's greater than or equal to.
So you don't have to get a building
greater than or
permit,
equal to.
you have to get a zoning permit for,
If it's 10 by 10, you still would have to have a zoning permit.
yeah.
Regardless of the construction.
And there's no provision about accessory structures, detached accessory structures, any reduced setback.
No, sir, we don't. That's a common question as well. Because I do know that other communities have that. I've worked in other communities that have reduced accessory setbacks, but we do not.
Mhm.
Southern Shores does not.
Okay, any more questions for Wes?
I did have a question for the applicant, if we can go back.
Well, maybe, Mr. Susi, you can question Wes. I mean, it's in our hearing, we have called on the town, the board has asked questions of the town, and the applicant may cross-examine the town. So you're more than welcome to ask Wes anything at this point.
My only question for Wes would be, I think he believes the shed location meets the spirit of the setback rule.
I can't answer as to whether it meets the spirit, but I do believe that it was your intent to meet all applicable requirements. By removing the shed from the previous location and moving it to the current location. I do believe it was in good faith, and I do believe that you were attempting to do the right thing.
Thank you.
Michael?
When did you purchase the property?
I purchased the property in August of 2020.
Okay. And when you did that, did you receive any survey as part of your closing documents?
I did not. Apparently, it's not required in North Carolina.
So you didn't need the old survey at that point?
Correct.
Okay, well, we've called on the applicant, we've asked questions of the applicant, that Wes says he doesn't have any cross-examination of the applicant, so at this point in the hearing, it says to call on the town to present the evidence. So Wes, do you have any evidence that's not before us tonight?
No, sir. The evidence from staff is the staff report that was submitted with your packets, posted on the website. With the, I would like to note and make the changes wherever there's a reference to east side of existing single-family dwelling, that should be changed to west side.
Okay.
Other than that, I don't have any other evidence to add.
Okay, so The West doesn't have any evidence to present other than what we have in our packets. So we would have another round of board questions for Wes. Anybody have anything else to ask with Wes? I'm assuming that when we start our discussion, we keep the discussion among ourselves. Can we ask you?
It would be preferred if there are any questions that be done at this time before you all close the hearing
Yeah,
and go
that's-
into discussion and vote.
Yeah, that's what I'm thinking. So before we go have our discussion and vote, does anybody have any further questions for Wes as far as what he's presented to us?
I have a couple of questions. Procedurally, let's say somebody came in and got a zoning permit. They only needed a zoning permit for a shed. And they produced a plan, the permit was issued, they go and locate the shed. What would be the normal process to close that permit out?
If the shed that they are proposing is close to the setback requirements, or if lot coverage, the existing lot coverage is at 29 or 28 point whatever, we will require a new as-built survey. It doesn't matter what the size is. It depends on the proximity to the setback distances and its closeness to the maximum 30% lot coverage requirement. And if this as-built survey is not required and the building permit isn't required when the building inspector goes out, then it's usually verified in the field.
And do you give the property owner, or is there a record that it's final, that it's been a final inspection approved?
If a building permit has not been issued, no, we do not have a CO or anything like that for a shed if it's just a zoning permit that's been required.
So we've got the copy of the zoning permit and the building permit here.
Right.
So what Wes is saying is anything under 144 square feet, you only have to have the zoning permit, and there's no sign off on that, is what you're saying. Once you get the zoning permit, that's it.
Unless an as-built survey is required as a condition in the
Right.
zoning permit.
If it's close.
Yes.
Okay.
But in this case, because of the deck, they needed a final inspection under the building permit.
Well, correct, but also the shed falls under the building permit as well. So the building inspector not only inspects the deck in this case, but he also inspects the shed.
Right.
And if and when a certificate, or, a CO is issued, it will be for the deck and the shed.
Anybody else have questions for Wes before we start going down the line here and vote? Okay, well, I'm going to move on to item 3, which is discussion and vote. Just want to remind everybody when we go down this list, a 4/5 majority vote on each of the 4 criteria is required to grant the variance. So what we're going to do is we're going to go from 1 through 4. And after we talk about 1, we're going to vote, and I will record it, Wes will record it. And we will proceed on and vote on each item after we've discussed it. And then if 4/5 majority rules the day in all 4 questions, then the 5th vote would be whether to approve the variance with conditions, or deny the variance. Everybody clear on procedure there? Okay, so number 1 says, does a strict application of the ordinance result in an unnecessary hardship for the applicant? Highlighted in yellow, voting yes is for granting the variance. Any discussion on that? Do we know?
Yeah, I think, unnecessary hardship. I think unfortunately, this was a unusual situation. It's not, I don't think, a variance that we would normally be sitting here and voting on. But because of the older survey and because there wasn't a newer one, and I did go by the property, and if it is moved to the front yard, I agree. It's not the nice place to be, and to me, that's not the Southern Shores look that we want either. So I think this is unique, and I think he did everything right. I think Wes was trying to help him out. I think everything was done in good faith. Nobody erred with lack of information because they thought they were working on the information they had in front of them.
Right.
So, yeah, these questions, to me, yes, they're there for a purpose, but this is such a unique situation.
Yeah, I agree, but procedurally, we have to go through it.
Yeah, I think it would cause an unnecessary hardship. He'd have to move everything again, get a contractor for the third time. Third time, am I correct on that? Third time? Yeah, for the third time, I think this causes an unnecessary hardship to the applicant.
I agree with both of you, and
I vote yes.
I haven't asked for the vote. Settle down.
It does.
Michael, you got anything?
No, I think, the cost is not significant, but I think it's still a hardship and it's unnecessary.
Okay. All right, well, I'll call for a vote. Once again, voting yes is for granting the variance. Yes?
Yes.
Yes. 5-0 on that one. Okay. Number 2 says, does the hardship result from conditions that are peculiar to the property? And once again, voting yes is for granting the variance. I would say loosely that the condition that is peculiar to the property is a survey that was
Way out of whack.
whacked out big time in 2005. So yes. Anybody have any?
Yeah, I agree with you. I think that survey is peculiar to the property, and he followed what the survey said.
No,
And I would say to that point, if we get to the point of conditions, I would suggest that the variance be granted based on our recognition of the record.
well, and we'll get to that. Okay, so on number 2, we're going to vote. Voting yes is for granting the variance. I'm voting yes. All
Yes.
Yes.
say yes. 5-0 there. Moving on to number 3. Does the hardship result from actions taken by the applicant or the property owner? Once again, loosely, I would say that the actions were in good faith on what was provided by the town. The town, in good faith, told the applicant where the shed would fit. So I would have to say that no, the hardship didn't result from actions of the applicant.
I agree with that.
Same.
You okay?
Yeah. I-
Okay, so for number 3, voting yes is for denial of the variance. I'm voting no.
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 No. Michael?
I'm-
No.
Yep.
Okay, so 5-0 on that. Number 4, is the requested variance consistent with the spirit, purpose, and intent of the ordinance? Voting yes is for granting the variance. Once again, I feel like the spirit of complying was certainly there. And I just think that the variance would be consistent with, Jan, what you were saying, that why force a hardship and make it worse rather than better? So for number 4, voting yes is for granting the variance. I'm going to vote yes.
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 Okay, so 5-0 on all 4 conditions. Now, getting to what Michael was saying. Board members, you are to make one of the following decisions. We can approve the variance, we can approve the variance with conditions, or we can deny the variance. And I am certainly amenable to putting some conditions on here for approval. So I guess to your end, Michael, I would like to discuss approval with some, I would say, minor conditions.
To me, the only condition I would look at is that the variance is approved, but for this shed only, specifically for one item. So nothing further can be placed in the setback.
I wrote down conditions that I thought of, and to paraphrase what you just said, Tony, I just said no future alterations to the footprint
Right.
without a permit.
Yeah.
So everybody reasonably okay with that?
Seems fair.
Wes, and procedurally, were you writing this down?
Yes, sir.
Okay. My first one would be that they need to move the fence off the Civic Association property, and get that fence out of someone else's property. So that would be a condition, I'm sure, that would be legitimate and in order. I mean, you can't put a fence on somebody else's property. Not that it's doing any harm. We know the area, it backs up to the pond, but it is on someone else's property.
And then I just have another question or discussion, and that is, by approving this variance, we realized, the mistakes that were made, and it was an unusual situation. However, if they were to sell the property and a new owner purchases it, would the variance, I don't even know if you can do this legally, would only go with this owner? It
No,
goes with
it
the
runs with the
land.
land.
So they would still have the use of that, same thing. And the only reason I say that is just to protect, I think, the planning board from future people coming and trying to.
Well, what I was on the third condition that came to mind that I wrote down was along those lines, Jan. I would say that we would need to have, or the town would need to have on file, a certified letter to adjacent property owners acknowledging encroachment, which it's encroaching on their side setback line, but that it would acknowledge encroachment with the understanding that the shed is portable and can be moved. I don't know if there's any binding element to doing that, but it seems to me that a shed that's not on pilings or is more permanently affixed, couldn't be, if, like you said, Jan, that someone came in next door and went, wait a minute, this thing's, way too far to my side of this lot line here.
Well, but they got notice, right?
Yeah.
Abutting property owners received notice
Yeah,
for this application.
Yeah.
they have, this,
Yeah.
is it on record? Have they replied back formally?
I received email correspondence from 2 of the adjoining property owners. And one of them said that they had no objection to the location of the shed where it is now.
Is that the property owner to the west of,
Matsko, I think it was Matsko,
East.
so east.
east?
He's east, yeah.
Does
Well, and
the,
they're less impacted. The property owner to the west at 19 would be the one that would be impacted, I would say.
She was more concerned about a fence encroachment. And looking at the survey, it doesn't look like there's much of an encroachment, if at all.
No, there's none on that property at all.
And they had the right to come tonight to talk, right?
Correct.
They could not attend,
Mhm.
but they were given notice.
if the shed is destroyed, do they get to and put another shed in?
I don't think so.
I would still, I mean, what you said about the property owner at 15 to the east, if we had that for 19 on the west side, which is more impacted than anybody on the east side, they would be, the east side would be impacted if we said, no, you got to move it out there in the front yard.
As I said, they did, I mean, they didn't come out and say, I don't think they just came out and said, we are in favor, but they didn't say that we were opposed, and they were more concerned about a fence encroachment.
Mhm.
But in any case, we can't take any of that into consideration because it's not put on the record.
Right.
I mean,
So, how do you feel about putting it on record that they are in agreement or that they are acknowledged? It's not up to them to, I mean, we're the ones granting the variance. It's not up to the property owner to challenge it. I mean, they should have notified us prior to tonight, I would think.
yeah, I don't think has any bearing. It didn't have any bearing on me, the lack of it, or, and I mean, to the other comment about the fencing that's on the Civic Association property, I don't think that has any bearing on this either. So I wouldn't condition it to that.
Well, what would you condition it to?
My only suggestion is that it's conditioned based on the application that's submitted and that they are allowed a variance for the shed as installed. And that it's based upon the materials provided to us, meaning that if there's a subsequent survey that shows that it's an even greater encroachment, that they're still entitled to maintain and keep that shed.
As far as the property with the Civic Association, this occurred when I was on the Civic Association at another location, and it was up to the Civic, we notified the Civic Association, and then it was a Civic Association that made the decision on yay or nay, not,
Yeah.
that's how it worked when I was involved with this one other time. So, it's up to the Civic
I
Association.
wouldn't
not
mandate
us.
it on, because if we put that as a condition on here, then it's imperative for the town
Yes,
to enforce that.
yeah.
And we can only dictate what the town can do. We can't dictate what private parties are going to do. And if that becomes a whole nother situation, that just really ties the town's hands.
So then what you're saying is no conditions in.
Well, the only condition would be to the application submitted. I don't see a need for any other condition.
What do you think, Ed?
Well, by granting this variance, it doesn't say everything else is fine. If the, it doesn't say that the encroaching fence on the civic association is okay and legit. So if the civic association wants that fence removed, it'd be up to them to say, get it off my property.
Yeah. I guess in theory, I would agree with that, but
Yeah, I,
do we just want to, I mean, I do think that what you were talking about, what I've written down, no future alterations to the footprint without a permit. I guess that's a given though. I mean, that's, wouldn't really need to be a condition because it's a given that they have to, I mean,
Right.
having gone down this path, I don't think the applicant is gonna not do anything over there without coming to see Mr. Haskett first. So what I'm hearing is we'll skip the conditions and just vote to either approve or deny the variance.
I do.
We okay?
Yep.
All right, then I'm gonna take the final vote to all in favor of approving the variance, raise their hand, please. It's 5 raised hands, so there is no vote to deny. And we will approve the variance as presented. Okay, thank you. Wes, anything else we need to?
Well, she has a question.
Oh, I'm sorry.
So does approval of this then close the building permit?
Not yet, no ma'am. So now that the variance has been approved, you're allowed to leave the shed as it's located. You've already turned in the as-built survey. Mr. Clark has already been out there. I'll talk to Mr. Clark, and if he needs to go back out there, he will. I know he looked at the shed and made notes about the shed. I don't recall where we stand on the deck, but if Mr.
The deck was approved.
Okay.
And I asked him to look at the shed, and he said, you're right, that will allow me to not have to come back.
Yep, okay.
Noted.
So as long as he's okay with that, as he's seen everything he needs to see, then we will close the permit and you will receive a certificate of occupancy / compliance.
Good, thank you.
Okay, well, we will shuffle some papers around and then move on to lot width. Get these up out of here. Everybody want to shift gears and anybody want to take a break before we?
No, I'm good, maybe.
Keep going.
All right. Item B under new business is ZTA 23-05, zoning text amendment application submitted by the town of Southern Shores to amend town code sections 3657, 36202, D2, 36203, D2, 36204, D2, 36205, D2, and 36206, D2 to amend the town's current lot width requirements. Okay. Wes, everybody got Wes's staff report? Wes, you want to paraphrase
Yes, sir.
the staff report rather than read?
Yes, sir, I can do that. So in an effort to remove ambiguity from the town's lot width requirements following an appeal of a recombination plat last year, the town council, as recommended by the planning board, approved text amendment to amend our lot width requirements. That was on June of this year, the council adopted it. However, at the time, that ZTA made the town's lot width requirements more strict. And that was because we were removing the ambiguity. And at the time, there was discussion where we said that we would revisit it so that we could address cul-de-sac lots, irregularly shaped lots, however you want to address it. So this is another round of proposed amendments in this ZTA. This includes an amendment to building setback line definition, which removes the word minimum, so that it says a line parallel to or concentric with the street right-of-way establishing the allowable distance, not the minimum allowable distance. We also amend the lot width definition by stating that it means the width of a lot at the required building setback line measured at right angles to the rear lot line. So the way it's worded now, as adopted, it's measured, the lot width is measured at the front property line. So now we are going back to the building setback line. Minimum lot width is 100 feet at the building setback line. And again, there's no ambiguity as to minimum. It's at the building setback line. And that is 100 feet wide at the building setback line. We also are providing a deviation from that 100-foot measurement at the building setback line for cul-de-sac lots or lots that front a cul-de-sac by saying that the building setback line may be established up to 80 feet from the front lot line. For all other lots, the building setback line shall be established 25 feet from the lot line. So the intent there is to the 80 feet. I mean, you all probably have questions on where the 80 feet come from. And using Dare County GIS, I did some measuring on some cul-de-sac lots. Mostly, I was looking at Ocean View Loop. And if you look on the screen, you'll see that two of the lots are right at 80 feet wide, 100 feet wide at 80 feet. Another one is 148 feet wide at 80 feet, and then another one is 89.2. It would be close on that one at 80 feet. But if you do go look at other cul-de-sac lots, the lots are wider than 100 feet if you go 80 feet back. So that's something that we can discuss if you all have questions or heartburn about that. But the intent, we're trying to cover all the cul-de-sac lots so that they are not non-conforming. So they're not considered non-conforming if and when someone wants to develop it, especially if it's under same ownership as the adjacent lot, if it is also non-conforming. So that is the intent there. And there is some wiggle room, I think, if you all wanted to make a change so that that 80 feet is a little more lenient.
Can you pull up that sketch that
Yes, sir.
I sent you? I mean, that was from a while ago.
Yeah. Hang on one. I just wanted to say, if there is heartburn about the 80 feet, I would suggest that it reads something to the effect of, and this is for lots that front a cul-de-sac, the building setback line shall be established at the point where the lot is 100 feet wide, up to 80 feet, whichever is less. But we can come back to that. Here, you want to see the sketch?
Yeah, I mean, it's just pretty arbitrary. But we looked at this in April when we were talking about this, and I added the 80 feet. I mean, it's pretty much to scale what's up there. So in that particular one, you see where the 100 feet is, and that would be off of the front property line. But I mean, it's just another example of a typical cul-de-sac lot. there's bound to be some atypical cul-de-sac lots.
I think part of the challenge for me, I guess, is that we've got now multiple terms in here that are defining a similar thing, you know, because we were amending the definition of building setback line. We're using that as a regulatory term for determining lot width compliance, but you also have yard and front yard that isn't changing, because here you're saying, how do you determine when minimum lot width is achieved? And that is setting your regulatory limit for your minimum, for your building setback line, but there's no change to your minimum yard requirement. And I think that's going to get very confusing for people. You know, I was just looking, even the definition, or even where minimum yard requirement is laid out, it's dimensional requirements, minimum lot size, minimum front yard, or minimum width. And then, actually, now that I'm looking at this, I think Municode may have not.
There is a mistake in 202D.
Yeah, 202, the D2, yeah, they didn't.
They didn't
Draft that correctly.
I've noticed that, and we're gonna make sure Municode gets that right.
And
But
then-
if you go to 202, 203,
Yeah,
or 204,
the other ones look right. Well, but then you have minimum yard in parentheses setback.
right?
So I think that's going to be confusing, but I also wonder if this is a solution in search of a problem, because the minimum lot width requirement is really more concerned with the creation of a lot and not necessarily the location of a structure. And so
I've always had a hard time with how it's defined and still is defined, the building setback line.
mhm.
I mean, if you go back to the sketch, sorry, that dotted line is what, Wes? What do you call that dotted line on that?
Setback.
Yeah.
But I mean,
They're all setback
the
lines.
definition is yard.
Yeah.
Yeah, but
Yeah,
it's it's commonly referred to as setback.
But when it's called the building setback line, to me, the building setback line is that dotted line that says you may not exceed the building setback line, whether it's the front, the rear, or the sides. I still like the building setback line definition in 30-02, which says building setback line means the line within a property defining the required minimum distance between any building and the adjacent right-of-way or lot. That takes care of what the definition of building setback line is, rather than focusing, the building setback line is the front building setback line. There are three different building setback lines there, the front, the rear, and the side. But yet we want to define building setback line as the front line, which I think is misleading. And then like you say, Michael, we've got lot line front, lot line rear, lot line side, they're all defined. But I don't think it would be too out of whack to define the building setback line individually. The front is this, the rear is this,
You probably,
the side is this.
well, but I think you probably have definitions for yard for all of those, right?
We do. And I guess,
But it's not a setback. I mean, it's defined as a yard.
Well, but that is the regulatory requirement, is in the dimensional regulations, it's minimum yard requirements.
it actually is in parentheses.
Setback
It
is.
says yard, parentheses, setback.
Right.
Right here.
Yeah, they're all,
Minimum front yard setback.
Yeah.
Side yard
I mean,
setback.
usually the way I've seen it phrased, because it was always for me setback, and then the first time I ever saw yard in a regulatory requirement, it was not, your yard was established, your minimum yard of a certain required width was established by the minimum setback. So your yard has to be free and clear because you've set back the required distance. So they work in concert with one another, but we have to make sure they work in concert with one another. But I also, I don't know that we need to reset I mean, here, what this is proposing to do is create a different yard setback requirement for lots on a cul-de-sac. Which I don't know if that's the goal, or is the goal here to make sure that the regulations don't preclude the creation of a lot on a cul-de-sac, because they currently do.
Well, I'll just answer that if I may. The intent is, like I said earlier, one, to not render our existing cul-de-sac lots non-conforming, but two, so that it's clear that when lots are created, whether it's through subdivision or recombination, that it's not ambiguous and that it's clear that the lot is 100 feet wide at some point. And based on the measurements using GIS, 80 feet was where we were looking to start. But that number may need to go out, and it could be added in there up to a point not to exceed, or whichever is less, or something like that, wherever 100 feet wide is achieved and not beyond that point. Either from the front lot line or building setback line. So in the cul-de-sac language, we're saying that it's still from the front lot line and not from the building setback line. That's the difference in what we're proposing as well.
Before the change was made, how was it regulated? Was it just where the lot met the width requirement?
I'll show you.
well, if you remember, in April, we had one version
Mhm.
and we thought we were good, and town council adopted the second version that we looked at, I believe. Or maybe it was the original version, I can't remember, but we had two versions. And town council adopted the March 31st version.
It used to be minimum lot width, 100 feet measured at the building setback line. And then building setback line was the same definition as in the ZTA, but it had the word minimum in it.
Yeah,
So how was that regulated? On a cul-de-sac lot before?
It never specified or differentiated a cul-de-sac lot from any other lot.
So what I'm asking is, you had a cul-de-sac, could they have located that structure in front of the 100-foot width requirement?
On a cul-de-sac lot?
Mhm.
I don't think so. The existing cul-de-sacs that we have with the existing homes, those homes were built 100 feet back.
They were built.
Or built where the lot is 100 feet wide,
Okay.
excuse me, I'm sorry, at the building setback line.
I mean, I don't think you give a dimension. I think you just say that.
Where the lot is 100 feet wide.
That's all you need to do, I think.
That makes it simpler.
That way you won't have to battle between 80 and 60 and 100, or 90.
It's just another, one less number to worry about.
Yeah, if it's
Yeah.
just if it's just flat out 100,
Where the lot becomes
it
100
was
feet
100,
wide.
it's very clear that way. And it's, otherwise, as I said, it's a floating number with 80 foot back. It's a floating number. But 100 feet, I think, is 100 feet width is kind of clear for anybody reading it.
Now, I've also seen it where it says you have to maintain that depth at least through the depth of the structure. I don't know if you need to do that, but, you know, you could get somebody that flares it out and then tapers it back in too. But I don't need to get that complicated.
So what do we want to do as far as that language for cul-de-sacs? I mean, we're working from the bottom, going up to the top, I guess, but, so what would that language be? I mean, what,
Yeah, well, I think if we were to say it's at the point where the lot is 100 feet wide, that might open the door back for ambiguity, where someone could say, all right, my lot is 100 feet wide here. I'm going to make it 70 feet wide here, 60 feet wide here, 20 feet wide here. I mean, would you be okay with that?
I mean, that's what I was saying,
Yeah.
is that I've seen them get as
Yeah,
complicated.
they could make a diamond.
Yes, they could.
But it wouldn't really be considered a cul-de-sac lot at that point, though. It would just be a point on the back, maybe, in the rear.
I mean, I think it still would be, but you might be chasing something too
Yeah.
that wouldn't really happen.
have you got those measurements on a lot with a house, Wes? I mean, is there a good clear one out of those ones that you were?
Oh, yeah.
Who's your diamond?
This one,
Yeah, that would be,
number 2, Ocean View Loop.
so,
And then this one, yeah, both of these have houses, and it's right at 80 feet where it's 100 feet wide.
mhm.
Sorry.
Yeah, I don't know that that's an issue. I mean, I'm just sketching it out, but, I mean, there may be somebody,
So-
you know, one lot wants to flare out a different way, you know, as long as it meets the minimum lot
The-
size.
The total structure has to sit back
Yeah.
behind the,
Behind her.
I mean, at some point, the structure has to sit behind the setback line, the front setback line.
Mhm.
Yeah, and I think the goal here is to make sure that it doesn't look too dense, that you don't end up with flag lots and you have one house in front of the
Mhm.
other, or if you have, you know, them too close to one another.
Well, and it's not that we're trying to preclude building on cul-de-sac lots. What we're trying to do is preclude from creating lots that should have been recombined and getting more lots out of recombination. I think that's what the objective is. I mean, we're not trying to render a cul-de-sac lot as unbuildable.
Right. Well, I appreciate your feedback, and I mean, if y'all want us to go back to work on this, we can, and come back to you again.
I feel like, I mean, this is from definitions. I just pull this off. I mean, in lot lines, if you go to the definitions, Wes, and see what everybody thinks about it, this was the lot line. Start off with lot line. In lot line, you know, it means the lines bounding the lot as defined herein. It goes lot line front, lot line rear, lot line side. You know, then if you go down to yard, you go over to yard at the end. You have yard, means required open space, other than a court, blah, blah, blah. Yard front, yard rear, yard side. Why can't we do that with the building setback line and say, building setback line front, building setback line side, building setback line rear? Because right now, building setback line means a line parallel or to or concentric with the street. It doesn't say anything about the front, the rear or the side building setback lines.
Right, because I think the way it's currently written, it's applicable only to determining lot width. And whether that's a problem or not, but that's why it's written that way. 'Cause
Yeah, but for clarity, in yard, they did, they defined yard front, yard rear, yard side. In lot line, they defined front, rear, and side. So why can't we do it with the building setback line?
Because the regulatory requirement, the dimensional standard is not building setback, it's yard. So the minimum, we don't have a minimum required building setback. We have a minimum required yard. And I think I'm not saying we can't get to where you're going, but it will require some more
Yeah,
greater tweaking.
it would alter this ZTA the intent is not to change anything on what, staff has tried to put forth here. It's just, that dotted line is on a survey is MBL, minimum building line. It's a setback line. We looked at it with these people's, the Susie's survey. There's that dotted line around those four corners of a parallelogram they're building setback lines. Call it what you want, but the front parallels the road or is concentric with the road, and the sides are. Yeah. So I would just say we create two more definitions and define the side and rear setbacks and the front. would be
Setback
just as it
line,
is.
front, rear, and side setback line, building setback line?
Pardon?
Add a new definition for
Ju-
building
you-
front, rear, and side building
would-
setback line?
It would basically be building setback line in parentheses, front,
And then-
building setback line in parentheses, side, building setback line in parentheses, rear. Then, it's
Well, I think.
So one side of that dotted line is yard, the other side is building setback.
yeah.
It's one line, but it has.
Yeah, but if we're defining building setback line, to me, that definition's been in there for a long, long time. The building setback line. We're
Well,
just clarifying it. It's not just for the front lot line that's, facing the street.
well, just for discussion. This is about the building setback line for this lot. Based on these measurements, it's not exact. Just for discussion. This would be, oh, excuse me, wait a minute. I've got that wrong. 25 feet. And draw another line. It's not wanting to cooperate. So what you're saying is, why have the definition for yard if you can't put a structure within that 100 feet from the 25 feet from the front lot line?
Now, I'm not even really thinking about yard. I'm just thinking about defining the building setback line in a broader term. Use the front setback line for what we have in the ZTA, but then define what the side and rear setback lines are. Building setback line.
and leave yard as is?
I don't think you can.
I don't, yeah, yard is just in there. A yard is defined front yard, rear yard, side yard. I think that the building setback line, I'm not for altering what it says for the front. I mean, that's the issue here is the front building setback line. But we might as well go a step farther and define building setback line in parentheses, rear, and in parentheses, side. Just like they've done in lot lines and yard.
But if building setback line is the measuring point, what would be the purpose of saying the rear building setback line? Would there be a measurement there?
Mm-mm. No. There wouldn't be one on the side either.
What is the purpose of regulating the front setback? You're talking about where you can start construction from the front?
Mm-hmm. Yeah, where, like Wes was showing
Right.
in that cul-de-sac.
You had one property that was kind of over that line. So
Well,
the purpose for aesthetic look is the purpose for, not preventing ADUs to be built in that 100-foot setback? What is our goal by regulating this?
I always thought our goal was to limit the amount of lots that are under same ownership that are large enough to possibly, rather than recombine two lots, they can, I'll use 55 Skyline Drive for my example. There were 4 non-conforming lots on property, and they weren't recombined, and I still maintain they should have been by the seller. But those lots were non-conforming, and they did a brilliant job getting 4 lots out of there that were 100 feet wide. I'll take my hat off to whoever figured that one out. But I think the mood is in the town, and I think the town council, mayor's expressed this while she sat on this board, was we're trying to eliminate creating more lots that would be non-conforming. How we're doing it is a little convoluted, in my opinion. But you can click on, I think if you click on the edge of that lot, Wes, you'll show 2 property lines, like right there. Will it go to, yeah, there you go. So that was, at one point, that lot didn't look like that.
Right.
And you,
The purpose of setbacks and lot width is to create uniformity, to create some uniformity standard for lots.
Mhm.
There is an argument to be made that as long as you have the requisite area, then it doesn't matter. You're still netting the same amount of density.
I disagree.
Well,
The way that the
if we're
ordinance was.
talking about area
Yeah.
over, units over area, you can't disagree with that, because
Well, the way the ordinance was written, any lot next to another lot under same ownership
If they're-
shall be
right.
recombined
If one
at
of them
the
is
sale,
non-conformity.
at the sale.
Right. If one is non-conforming,
under same ownership.
to remove the non-conformity. Right.
That's right. And that's
Correct.
what the town has always strived to do. However, in this particular case, I'm still not sure we couldn't have won this thing, but our attorney said we couldn't.
Well, but was the goal here, and I don't know that any one of us can say that, but was the town's goal here to limit the number of units created or to limit the uniformity of lots?
I think the limit, the number of units would be, I mean, from a personal standpoint, I think it was the number of units rather than getting 2 units on 4 non-conforming lots under same ownership. They got 4 units rather than 2. And I think in all of this, that's what we're trying to figure out is where is the southern lot, where is that 100-foot setback line? That's a flag lot all day long. And that's what we were trying to eliminate.
That lot right there?
No,
The other one,
first,
Yeah.
You said the one on the south, right?
well, yeah, but as
The
far
next
as
one up.
the flag lot,
Right.
yeah. And that's what we were trying to curtail.
Again, though, but because of the concern that they were getting a unit that we didn't think they were entitled to get? Or,
2 units.
okay, 2 units that we didn't think they were entitled to get because we didn't like
that one and the one just.
the layout of the lots?
Mhm.
I mean, I'm playing a little devil's advocate.
Yeah, no, hey, I wasn't here.
Because there are some places where you have that area, you have that requisite area, you can build 4 lots. And we won't even make you create a lot. You can just have it under condo ownership.
Mm. In Southern Shores?
No.
No.
In communities is what I'm saying. But think about it this way. Think about it this way, right? So let's say that lot had some natural resources on it or less than desirable areas that could be developed.
Mhm.
Would we rather they cluster where those structures are located and preserve the
Hey,
areas that are less desirable from a development standpoint?
if it was anybody else that owned those lots, I would be worried. If our people that, we've had 3 planning board meetings discussing what to do. If they got a hold of something like that, yeah, I might be a little bit worried, but those 4 lots that were created there will be well done. I can guarantee you. I know the owners.
Well,
One of them sits on this planning board.
but aren't they non-conforming now?
They are now.
So they actually
Legally.
have to be combined?
They're legally non-conforming.
No.
They're separate lots under separate owner or.
Oh, that's true. That's true because the June date, right?
Yeah, that we put in the, yeah.
Yeah.
Legally non-conforming.
Anyway, we're getting way off track here from, what we're trying to achieve. I'm certainly willing to talk about this some more and maybe,
I can meet with a couple of y'all or
yeah.
the town attorney, maybe we can also now and then.
Did
discuss
Lauren,
ideas.
how involved was she in this language or how certain was she that this was unambiguous?
If you recall, Mr. Hallow, Johnny Hallow
Mm-hmm.
with HREM,
Yeah.
he assisted the town with the appeal hearing and he assisted the town with drafting the language afterwards. This ZTA language was sent to him. He reviewed it and we discussed it. He was okay as far as with eliminating ambiguity.
Mm-hmm.
And if I recall correctly, he asked for comments from Lauren and Philip, and they didn't provide any comments.
Well, I think it needs more work.
And we're okay with that. I mean, that's fine. We
Yeah.
can, we can come back to you.
Well, one thing big that I saw was in what the ZTA that's here right now, 2305. If you start going through the districts, RS1 is 100 feet. RS8 is also 100 feet. RS10 is also 100 feet. R1 low density is also 100 feet. In the previous renderings, they've been less than 100 feet, 75, I think, and maybe 50. What happened there? Or was that just kind of an oversight?
Yeah.
If you look at the.
Yeah, if you schedule district regulations.
Yeah, which is current. They have RS 8 at 75, RS 10 at 75, and government and institutional at 50.
Right. And the ZTA should reflect those numbers.
So that would be a big change, substantive change to the ZTA.
Right.
Beyond that, I'm up for revisiting this.
You may want to use this time to create a table for the dimensional standards.
Like, that's what we did with signage.
Yeah,
It might simplify things.
anybody want to keep talking about this, or we want to roll down the agenda here?
I think roll down the agenda.
I second
I'm
it.
glazing over.
I second it.
Okay. You okay with shoving that to another time?
Yes, sir. We'll go back to work on this and.
Do you need a motion?
No, I'll take your comments. I made notes and we'll go back to work on it.
Yeah, well, we probably need to get a couple board members and
We can do that. We can set up a meeting.
Staff to-
Call. Yep.
kind of spread out a little bit more and figure out what we're doing.
Be glad to.
Okay.
Glad to get your input.
And we can get that, there's a big screen. I know Cliff was able to patch in and look at it in the conference room.
Right.
Yeah. Okay, no public comment. Planning board member comments. I'm gonna take care of a little housekeeping right now. There was, we have rules of procedure that we got back. They became effective on 9/18/23. And I just want to make it really clear to everybody that's here tonight that the second page on the rules of procedure concern being removed from this board. And the definition or the criteria for removal on this board, on the planning board, is members of the planning board are expected to exhibit the highest ethical and professional standards. The town council may remove a member upon a majority vote, upon written charges, and after a public hearing. Item E says release from service. When it is deemed necessary to release a member from his or her appointment, the affected individual shall be notified by letter. Absences. Member absences are limited to 2 consecutive regularly scheduled meetings unless excused by the chairperson, and 3 total unexcused meetings per year. The town council may remove any member, if absent, from 3 consecutive meetings. We said early on, when I became chair, that the alternates were encouraged and asked to come because they are the alternates. Michael and Dan Fink they are members of the planning board that are alternates, and the alternates should be treated or shall be treated the same as the seated member. So we have a situation that one alternate is been chronically absent, and Cliff, our town manager, has taken some action there. But anyway, just want everybody to be aware that this rules of procedure is for the planning board to adhere to. We haven't had any problems with anybody sitting up here, and I would just as soon have a clean slate going forward. If Mr. Fink is amenable to being an alternate, if not, he can turn in his resignation and we'll find someone else. But anyway, I told Wes that I was going to read this tonight. So that's that. Anybody else have any comments? Announcements, Wes?
Yes, sir. You'll notice I left a copy of what is the 2024 Planning Board meetings and deadlines. Next meeting is scheduled for January 17th. That is not a third Monday due to the MLK holiday. But you have hard copies at your places, and if it's not already posted on the website, we'll make sure that it's posted as well.
Okay. And town council meeting is,
That's not the first Tuesday either due to
Right.
the New Year's Eve holiday. So I think it's January 7th, 9th, excuse me.
January 9th.
January 9th is the next regular council meeting. And that is when the public hearing will be held for SUP 2301, the mixed-use group development.
but it is going to be at the regularly scheduled town council meeting.
It's not regular, it's their regular meeting, but it's not the usual day due to a holiday.
Right. I'm just saying that
It's the
on
regular meeting. The
January-
meeting will begin at 5:30 PM.
January 9th will be a regular,
It's a
Town
regular,
council
it's a
meeting.
regular town council meeting.
because I've had people asking me, well, it's a public hearing, special meeting, there can't be public comment, but there can be public comment prior to, just general public comment prior to.
I spoke with Lauren. There have been ways it's been done different by different, based on different legal advice, I guess I'll put. In this situation, it sounds like there will be opportunity for public comment outside of comments provided during the quasi judicial public hearing.
So general.
But, excuse me, however, whatever comments are provided during the public comment cannot be considered during the quasi judicial hearing.
Interesting.
Yes, sir.
So it sounds like that there will be general public comment.
There will be an opportunity for general public comment,
Right.
but for example, if someone wishes to comment on the application or its specifics, the council will be directed or advised by the town attorney that they cannot take their comment into consideration.
Right. Okay.
If they become an aggrieved party.
If they're an aggrieved party, then they can speak, I believe, yes, sir.
Right.
And they'll be subject to the quasi judicial
Yes.
requirements and standards and procedure. But as far as general public comment,
Right.
I've been told that it's whatever comments they say
Right.
cannot be considered.
Well,
But I'm sure the town attorney will do a great job explaining all of that before we get into it
mhm.
the day of the meeting, the
Yeah.
day of the hearing.
Is this room going to be big enough?
No.
No, I don't see how you can separate out public comment and say, okay, you can have public comment. We'll talk about dogs barking and potholes and stuff like that, but you can't talk about, this action that the town council.
Well, she didn't say you can't talk about it. It's just, she said, that her words were,
You can't
the
consider it.
council can't consider the
Yeah.
comments.
Right.
They
sure.
can talk about whatever they want to talk about.
Yeah, absolutely.
A smart thing to do with this, from my experience in doing this in the past, is to say at the beginning, if you're an aggrieved individual, reserve your public content, your comments until the actual hearing. So you wouldn't want somebody going up there that's aggrieved, make a comment, and then get called again and more or less be redundant or add anything. It was always smart to say, if you're an aggrieved person, in other words, don't make a public comment until
You're sworn.
you're sworn.
Yeah.
So hold off instead of having redundancy, because I've seen that happen,
Yeah.
where somebody will go up and they'll as a public comment, and then they're the aggrieved person and they come up. So it just might be a smart thing kind of to say at the public comment aspect. If you're an aggrieved party and plan to testify at anything, hold off until you're called up as an aggrieved party.
Yeah.
It's just a suggestion, but I've seen that before where it suddenly becomes, oh my, here we go again, you know?
Does everybody have to be individually sworn? Or can
No.
the aggrieved public stand up and be sworn in for testimony at one time,
Usually call everyone up who plans on speaking.
Yeah.
individually,
Collectively.
collectively?
Like at the beginning of the hearing tonight, she asked myself and Mr. Susi, we both stood up and administered the oath.
Yeah.
That's typically, I agree with Michael Welch.
You have to call them up.
Mm-mm.
So, yes, sir, that's the hearing date.
But it's everyone's individual, at least to a degree, it's everyone's individual determination whether they're an aggrieved party.
Well, they may believe they are aggrieved, but I guess it's to be determined during the hearing if they are in fact aggrieved.
Yeah.
Right.
Yeah. The burden of proof is on who though?
For someone to say that they are aggrieved,
Mhm.
Yeah,
I'm assuming that it's on the person claiming they're aggrieved.
Well, I think then the applicant can dispute it.
That's what the applicant
Yeah.
could dispute.
Yeah. Yeah. All right.
Popcorn.
Okay. We're right there. Jan, did I hear a motion to adjourn down there?
Yes, you did, sir.
Okay.
I seconded it.
All in favor, aye?
Aye.
Merry
Opposed, none?
Christmas.
Yeah, Merry Christmas to everybody. Thank you. Ooh.